Good afternoon, everyone. My name is Maya Luria with TMC for Seniors, and we're continuing on with our Women's Health Month. And today we're going to be talking about how to navigate legal issues for women. I have Shanelle Schmitz here with me. She is with the Law Office of David Karp. Shanelle has provided us an amazing amount of information that we all need to know. And today she's going to be talking about some planning tips for women.
Great. Well, thank you, Maya, and it's great to be back as always. I love coming here and presenting. So as Maya was saying, I'm with the Law Office of David Karp, and I have my contact information here if anyone wants to reach out with any questions or any kind of estate planning concerns after the presentation. And of course, I have my legal disclaimer for anyone who's come to the presentation before. This is just going over the fact that anything presented in this PowerPoint is not formal legal advice. I'm just trying to provide education for you. If for your specific needs, it's important to talk to an attorney because everyone has different needs. Attorneys can advise you on what's important for your particular situation. So legal planning tips for women. So what I tried to list out was some important documents for everyone, and then also some practical considerations. And it looks like, it looks like it was cut off a little bit, but I'll go through it in the other slides because I want to make sure that you can take away practical information from this presentation, along with have a good understanding of the legal documents that are important to have. So the first, I would say one of the most important documents to have is a healthcare power of attorney. So in the healthcare power of attorney, that's where you nominate who serves as your healthcare agent. So who do you want to make healthcare decisions for you if you're not able to do so on your own? So let's say you're in a car accident and now you're in a coma. It'd be who would serve in your role to make healthcare decisions for you. Now, it doesn't have to be your spouse and it doesn't have to be your children. I have a lot of clients who come in and they don't necessarily trust that their spouse is capable of making the decisions that they want. So it's important to, think about who would make the decisions that you want to be made and have a conversation with them as well. And if there are no family or friends that you trust, there's professional licensed fiduciaries who do serve as healthcare agents. I always recommend that you meet with, maybe a few of them. Make sure that the licensed fiduciary is a good fit for you because they're stepping in your shoes. They're supposed to be making decisions based on how you would make decisions if something happens where you're not able. Now, within the healthcare power of attorney, you can also nominate a guardian. The idea of having a healthcare power of attorney is to try to avoid a guardianship. And a guardianship is where someone's appointed through the court to make decisions on your behalf. So if you have a healthcare power of attorney, it's to try to avoid that. But sometimes there's issues. So like, let's say one of your kids is not happy with whoever you have chosen as your healthcare agent. They might take it to court and try to get a guardianship over you. So in your healthcare power of attorney, it's important to nominate who you would want to serve as guardian if it were ever taken to court. Most people are just listing the agents that they already have listed as their healthcare agents. One thing I like to include is if there are any individuals whom you never want to serve, just have a statement in there saying that, because if I was the attorney representing you and I had to take it in front of the court, I can rely on that because that is showing that your intent was that they never serve as healthcare agents. So let's say you have a family member whom you think is going to make a contest and make an issue about it. We would list them as someone whom you never want to serve as healthcare agent and guardian. You can also include funeral and disposition arrangement authority within your healthcare power of attorney. And there's also in Arizona, it's called mental health powers. So you can give your agent the ability to have you placed in a locked psychiatric facility if the need ever arose. Now, a lot of clients will get concerned. They're like, I don't want to give anyone that authority. However, keep in mind that in order to have you placed in a locked psychiatric facility, there's steps that have to be taken, and the doctors have to agree that you need to be there for your safety. If an agent doesn't have that authority, then there would have to be a petition that would go through the court, and it does complicate things. So it just depends. Some people want court oversight if they were ever needing to be placed in a locked psychiatric facility. In that situation, you wouldn't want to give someone health care or mental health powers. If you're okay with your family members making that decision if needed, then I would advise to go ahead and have them list it. That way they don't have to go through the court process at that point. The living will is also a very important document. So essentially it's stating what would happen if there's an extreme situation. So let's say you're in a irreversible coma, a persistent vegetative state. It's saying whether or not you want life-sustaining treatment beyond comfort care at that point. And there's also the ability to have a pregnancy override. So that's something that us women have to think about if it could apply, whether or not you would want to be kept alive until the child is full term. And then there's also HIPAA authorizations. So your healthcare power of attorney will likely have a HIPAA authorization in it. At our office, we do a separate HIPAA authorization form. And the reason being is you can list on the separate form people whom you wouldn't want to make decisions for you. So that way they can at least get information on how you're doing at the hospital, but they're not necessarily the decision maker. So some practical considerations with healthcare powers of attorney. I listed some information here about who can help provide or who can help fill out healthcare directives for you if you're not working with an attorney. So TMC for Seniors provides free assistance, and they can always provide more information on that if you're interested. And I would highly recommend taking advantage of that if you're not working with an attorney, because everyone needs to have these documents in place. There's also the free state forms online, and I put the website there, and there's a advanced directive. Basically, it's a planning packet. So that's something that you can also fill out on your own. And of course, you could work with your attorney if you have one. And so one of the practical considerations I wanted to point out is it's really important to be able to, as your healthcare agent, to know what you're wanting and what your medical issues are. So what I recommend is having a list of medical diagnoses, current medications, physicians, if you have certain preferences. Let's say you never want to have chemo, even if that's what was recommended. You can list that out and put it with your documents. That way it's easy for your healthcare agent to find. And I would encourage you to have a conversation with your healthcare agent and let them know. That way, when there's an emergency, if it does happen, they're prepared, and it's going to be overwhelming for some people anyways. This helps them be able to know what you want, and it helps cut down on that overwhelm because now they have all of the information that they need. You can also upload your healthcare directives to the Arizona Healthcare Directives Registry, and I added the website there, or a private company like DocuBank. So at our office, we use DocuBank because there's certain benefits we like with working with them, but essentially they'll provide an emergency contact card for your wallet, and I believe Arizona Healthcare Directory does as well. And you can make notes on it as well about pets. If you have children or dependents at home who need assistance, like one of my clients, her child wouldn't be able to seek any kind of help if something happens to her. So we would list on the emergency card to make that the child is at home, to make sure that any kind of emergency personnel goes and checks and makes sure the child is safe. So think of things like that. If you have a spouse who might have Alzheimer's, then you would want to list that on the emergency contact card. So the great thing about the Arizona Healthcare Directives Registry is they're working with all of the hospitals to try to get everyone on board. I don't know the status of how successful they've been at doing that, but they are working to do that. So something to look into, something to consider. So the next very important document that I would say everyone over the age of 18 needs to have is a durable financial power of attorney. So this is only effective while you're alive, and it's there if you are unable to manage your finances. So if you become disabled and you are not able to pay your bills or pay your taxes, this would allow your agent to go ahead and do that on your behalf. We recommend at our office to have very broad powers. That way your agent can step in your shoes and basically handle all of your financial. And also we have other things like caring for your pets if you have pets. Sometimes that can become an issue when you have to take them to the vet's office. So, things to consider. It is a great responsibility and liability for the agent. They can actually be criminally prosecuted if they steal money from you or if they act without your permission. Let's say you're alive and they start taking money out of your account, they can be criminally prosecuted. And it's not always accepted. So we recommend keeping it updated every 2 to 3 years. If it's older than that, sometimes banks will refuse to accept it. Another trick to think about that we advise our clients is each bank has their own power of attorney form. So like, let's say you have a checking account at Wells Fargo. You can go to Wells Fargo and they have a power of attorney that's specific to that bank account. So I recommend for each bank to go ahead and fill out their form. That way they're less likely to reject the form. And you can also appoint a conservator within your financial power of attorney. That way, if for some reason the bank doesn't accept it, or the power of attorney isn't being accepted by the title company, then a conservator can be appointed through the court, and you're basically telling the court, this is the person who I want to serve in that role. Now you can also add language of if there are any individuals whom you never want to serve. So you can add that in as well. Some practical considerations to think about with the power of attorney is it's very, very important to trust the agent that you nominate. So like I said before, the agent can be prosecuted criminally, but someone has to notice what's going on. So if you're incapacitated and no one notices, that creates a problem. So number one, make sure you fully trust whomever you appoint as your power of attorney. That's my number one point or tip for clients whenever I'm meeting with them. And we usually do multiple successor agents. So rather than have like 2 together, we're usually recommending having 3 listed. So it'd be the first, and if they're not able to serve, the second, then the third. And sometimes the third might be like a professional, just so that there's someone's there in case if something happens to the first agent, you want to have a succession. Now, I also recommend having a list of assets and contact information available for your power of attorney. You don't have to give it to them while you're okay, but it's good to have, like I said before, a binder with everything in it. That way, if something happens to you, they're going to know where to find your assets. That's very important. Where are you receiving your income from? Now, if you don't have it listed, then if they were to hire us, we'd be working to kind of backtrack, and then we have to look through your tax returns, your former bank statements, and it can be very difficult to find certain assets. So it's really important to have it all listed out and try to make it as easy as possible for them, because they're going to be possibly thrown into a situation where it might be very emotional, and we want to try to make it as easy as possible for them to take care of you. So bank accounts, life insurance, think of the sources of income, brokerage accounts. If you have any financial advisors, CPA, or tax preparers, include that information for them. That way they can easily reach out to them, and they can serve to help them find different assets if needed. And then also consider having a list of monthly bills. And so some of the bills, I would say, like credit cards, have account information, contact information, or maybe just have like a little plastic sleeve where you stick those bills in. That way they know where to call, and they can make sure that things aren't getting aren't being paid late, and it's just easier for your agent if they need to take over and you don't have any capacity. Okay, so the next document is the will. So this is only effective upon your death. And within the will, you would name a personal representative or executor. And it basically tells the court how you want your property to be distributed. Now, a lot of people don't fully understand that a will does require probate court. So, consider that when you're setting up your overall estate plan. We'll go over trusts, a little bit about trust today. So if you have a trust, you'll still have a will, but it basically pours everything into the trust. With wills, you can have what we refer to at our office as probate-based plans or probate avoidance plans. So there are ways to set up your estate plan to try to avoid probate, but you still should have the will in place, and the will is kind of a backup because it does require probate court to work. And within the will, some things to think about is if you have minor children, you want to name a guardian. This allows you to tell the court, basically to say to the court, this is my intent of whom I want to raise my children if something happens to me. And you can also do this for an adult child who's incapacitated and unmarried. So if you have an adult child who has, let's say, Down syndrome, you can list in your will who can serve as a guardian and take care of them if something happens to you. And I highly recommend that. You can also name a guardian for your incapacitated spouse. So let's say you have a spouse who has dementia and you're having to take care of them. You want to make sure that it's an easy transition if something happens to you. So you want to make sure you name a guardian in your will. And there are a few other practical considerations I'll get to in a little bit about how to make sure there's a care plan set up. So with nominating an executor or PR, it's important that you nominate someone you trust. If you don't have anyone you trust, there are fiduciaries who can step in. There's also trust companies, but usually for a will, it would be a fiduciary. They're licensed through the state of Arizona. And again, you just want to meet with them and make sure you're comfortable with them. I do usually recommend having multiple executors in order of preference. So usually we're recommending having 3. Now, again, having the list of assets and contact information for advisors, bank accounts, life insurance policies, sources of income, brokerage accounts, anyone who's helping you with taxes, where is your most recent tax return. So if something happens to you and you pass away, whoever is managing your estate is going to have to look at paying individual taxes for you for the year, for the date of death year. So if you passed away today, they'd be looking at filing taxes for 2024 for you. So that's something that a lot of people don't think about. So this is all just to try to make it easier for them, just so that they know if you are working with a CPA that they can reach out to them. One common issue that I've seen as I've been practicing in probates is a lot of times it's really hard to find assets. And so if you don't have a list of assets, it may be years and years before your family members receive those assets. I had one case where the decedent passed in 2015. And if it weren't for his stepdaughter, who was absolutely certain he had some kind of retirement plan out there, who came to our office, let's see, I think it was in 2020 or 2021, so several years later, she was so determined to find this asset. And we ended up having to subpoena multiple banks to try to get bank records, to try to track down to see if there was this source of income. It was very expensive, but we ended up finding around $500,000 just being held there. And the financial advisor didn't know that he had passed, and they hadn't reached out to any beneficiaries. So in that type of situation, had he just had a list and given it to whomever he wanted to be in charge of managing his estate, we would have not had to jump through all of those hoops. And it was several years just because there were so many subpoenas. Banks are not easy to work with, unfortunately. So even if you subpoena them, they don't always follow it and you have to enforce it. So something to consider. And then with the probate avoidance plan, so if your goal is to avoid probate, there are ways to set up your beneficiary designations. So you can work with your attorney or advisor to basically set up to make sure all of your beneficiary designations are going where you want it. Something to keep in mind. So beneficiary designations will trump the will. So let's say you have an IRA and you have your 2 children as the beneficiaries on the IRA, but in your will, you disinherit 1 child. The beneficiary designations in the IRA on the beneficiary designation form is going to apply. So keep that in mind. I actually saw that case happen, and dad thought he was disinheriting his son, but he didn't. So son ended up getting half of the IRA, which he was happy about, but my client, his brother, was unhappy about it. So, things to think about when you're setting up your estate plan. You want to make sure everything is consistent and in order. Okay, so a trust. So not everyone needs a trust, but trust can be great for certain situations. So it's basically a private contract between you as a trust maker, trustee, and beneficiary while you're alive. So it is applicable while you're alive. Remember, a will is only upon your death. Trust is applicable while you're alive. So I like to tell my clients, think of it like a bucket, and you want to put your assets into that bucket either while you're alive or have them go into, usually if you can, and there's certain assets you can't have in the trust, but for most of the assets, you can have them in your trust. Anything that you can't have it, you would have it go into the trust upon your death. You want to make sure everything is in that bucket so that your successor trustee can manage those assets for you while you're alive. So if you become incapacitated, they'll be able to pay your bills through the trust, manage the investments, and you provide instructions for your successor trustee within the trust. So during life, trusts are very good for incapacity planning. One thing to consider within the trust is, so if you have dependents, so like let's say you have a child with special needs and they're an adult, so normally your assets, if you became incapacitated, would be used for only you. You can specify in your trust that you want them to also receive money from your trust if you become incapacitated. You can also do that. You can also specify for other people as well if you so choose. So let's say you have a child who's not dependent now, but you want them to be able to possibly get payments if you become incapacitated, if they need them for like health. You can specify that in your trust. At death, the trust becomes irrevocable, meaning unchangeable. So the trust provides instructions for how you want your assets managed and distributed, and it specifies who you want to receive your assets. Now, within your trust, so trust can be a lot more flexible than will-based plans. So if you are concerned about, let's say you have a blended family and you're concerned about your spouse changing your estate plan after you pass away, you can set up a trust that has protection for those children within. That way you can make sure that at least for your portion of the trust, your spouse can't change that. If you don't have remarriage protection listed in there, then your spouse could potentially just leave everything to his new wife. So that's something to consider when you're setting up an estate plan if it's important to you. You can also set up protections for your children. So a lot of times we work with clients to set up beneficiary trusts for their kids. It provides them asset protection upon your death. So if they receive the money in a protected beneficiary trust and they were to get sued, they were to get divorced, then in those types of situations, the assets would be protected from judgment creditors, from the divorce. So it's basically like a little safe for them. And you can still give them access to manage it, even though it's protected from others. So some practical considerations when you're setting up a trust is it's important to, of course, nominate successor trustees whom you trust. And again, to have multiple successor trustees in order of preference. We usually do recommend 3 as well in this case. If you don't have anyone whom you trust, there are licensed fiduciaries and trust companies. Now, one of the biggest factors with setting up a trust is making sure that it's properly funded. So you would want to work with your attorney and financial advisor to make sure that all the assets are properly either titled in the name of the trust or they're going into the trust upon your death. So if you don't have it properly funded, what happens is you end up with double administrations for your family members, which no one wants. It makes things more complicated. You would end up with a trust administration and a probate court administration. So it's very important to make sure that your assets are properly funded in your trust and to have the list of important contacts. Now, for my clients, we do keep that information within our file and we keep everything updated. That way it's one point of contact. So if you are working with an attorney, you can ask them if they'll be your point of contact. That way you can just tell your family member, call this person. They have all the information needed. They'll make it easy for you. So something to think about. So if you have dependents, children or other family members, so consider allowing payments to be made on their behalf if you are incapacitated. So I mentioned this a little bit earlier, but it bears repeating. So you can add special language in your power of attorney and your trust to make sure they're taken care of if something happens to you. Now, if you have dependents or spouse or children, anyone who has special needs, you want to have a care plan in place. So things to consider whenever you are setting up some kind of care plan is an immediate care plan. So if something happens to you today and you're put in the hospital, who will step in to take care of them immediately? Who's going to make sure that they're safe and they're taken care of? And then a long-term plan. So after the immediate situation, as it's going, what's going to happen to them long-term? Do you have a plan in place? Do you have preferences? And this is something that you can work with. So depending on the situation, if you have other caregivers helping, so I'll give you an example. One of my clients, her child is unable to do anything if his finger isn't lined correctly with an iPad. So he can't communicate without making sure that, because he can only move one finger. So in that situation, it's making sure that someone's checking in on him often, because if something happens to her and she just doesn't come home that night, someone needs to be there to help him. So things to think about. You can work with therapists involved, caregivers involved, the attorney involved, but it's really important to have something in place. Also to have lists of diagnoses, treatments, medications, physicians, and let the planned caregiver know where to find this information. So similar to the information I recommended for you, it would be good to have that in place for any of your dependents. That way it's easy for the caregiver to know who to reach out to, what kind of medications they're on. So just important things to think about. So potential problems faced by women if there's no estate plan in place. So we see this happen a lot, unfortunately. So if you're not legally married to your significant other, so let's say your partners, you've lived together for 20 years, but you just never wanted to get formally married. You didn't think there was a need to do that. So if there's no estate plan in place, you would have no right to your significant other's property. So there's basically, it's going to go based on Arizona law, and you have no claim to that property. You also have no decision-making rights. So you would have no decision-making rights when it comes to healthcare decisions. So if they're in an accident, you can't make decisions about whether or not they stay on life-sustaining treatment, financial decisions during incapacity, funeral arrangements at death. You can't make the decision that they get cremated. I've seen this a lot of situations where the partner doesn't necessarily get along with the surviving family members. And one example that I'm thinking of is the surviving partner didn't agree with the mom as to what would happen with burial versus cremation. And it ends up being a legal battle, but unfortunately the partner doesn't really have much legal standing to fight that battle. So something to think about if you're in that type of relationship. Really encourage your partner to set up an estate plan and set up an estate plan for yourself as well. For blended families, so this is another one that can be very shocking. If no estate plan is in place, not all property transfers to the spouse. So if the decedent is survived by the spouse, and has one or more children from a previous relationship other than the surviving spouse. The surviving children get decedent's half of the community property and half of the deceased spouse intestate separate property. So not everything goes to the spouse, and this can create a lot of issues. This is a very unfun conversation to have with surviving spouse. So something to think about if you are in a blended family, make sure that you and your spouse have an estate plan in place that addresses this. And so now I'm opening it up to questions.
So thank you, Shanelle. Let me, I have a couple of questions, and there's a lot of information there to unpack, right? And so I know it gets confusing. What are some tips to ensuring that you're not taken advantage of, maybe in terms of like financial abuse? How can somebody really protect themselves? I know that obviously you have the paperwork in place, but is there more?
So the most important thing is to have the paperwork in place and to nominate someone whom you trust. And if you don't have anyone whom you trust, have a professional handle it for you. There are professionals, licensed fiduciaries. That the biggest thing is finding someone whom you can trust. Now, unfortunately, it happens too often. And if there's no one with oversight, so if you become incapacitated and you list someone who's not trustworthy, sometimes there's not a lot of oversight over what they're doing because you're incapacitated and you might not have other family members. So that's where you really want to think about maybe having a professional fiduciary in that role. But I would say having the documents in place and then really thinking of really considering who you want to have listed.
Okay. Now, we oftentimes, I know here we've seen this, it's come up many times about maybe somebody who is single, or maybe they're a widow, and they don't really have anyone that they feel they might not have family around, or some friends who don't feel that they have anyone who can handle their planning with them. What are there any low cost public fiduciaries or any programs that would help somebody who may not have somebody that they could maybe name for some of their legal?
At this time, there's a definite need for that. To my knowledge, there is no longer a program that would allow for that. I was doing some research after the last presentation to try to find that. Unfortunately, I wasn't able to come across that. I do know some licensed fiduciaries do donate their time, but that's really a case-by-case basis. The public fiduciary usually doesn't get involved unless there's no one else to get involved. And usually that's only if there's money my understanding is only if there's money to pay for certain things. So it's definitely a need that needs to be met in this community that unfortunately, I don't have any resources right now.
Right. I knew we did years ago, and I haven't seen anything lately, but I guess what I'm saying is a solo senior, right? And I think the solo senior has been used before for something like that. And I know that question oftentimes would be asked. So I wasn't sure if there's been anything new out.
There are some licensed fiduciaries who have, a lot of the licensed fiduciaries we work with have good rates. So maybe it's something to talk to them about and see what you can plan. And I know sometimes they're willing to work with you. You don't usually pay them right now. They would get paid whenever they're serving as your agent. Sometimes they do have a file, like a file fee. So like opening a file for you and meeting with you for the initial meeting, they'll charge, I think one of them that we work with charges like $200 to do that initial meeting, but then they don't get paid unless they need to work with you. So let's say you become incapacitated and now they step in, now they're charging your estate an hourly rate. So that might help with the planning And then they also don't get paid for managing your estate until after you die. So it's not like you're paying them monthly right now when you set that up. It would only be whenever they start serving on your behalf.
Okay. And if somebody is in a situation where maybe their spouse dies, what at that point, what should they be doing to make sure that everything is lined up? Because I'm assuming maybe they might have named that person in their documents. So how do they handle that?
So it depends on the situation. So the PowerPoint presentation, I tried to provide tips for women, but also it applies to men as well. And it's something to think about when you're discussing it with your spouse, because I know sometimes one spouse handles all of the finances, and you really want to know where you can find a list of all of the finances. That way you can step in and easily manage those if something does happen to your spouse. If you don't have a list, then it can be complicated. So if they have an estate plan in place, then we would look at following the estate plan. If they don't, it just kind of depends on what kind of pre-planning they did, how easy or how hard it is for the surviving spouse. So the more organized their estate plan is, the easier it is. If they're working with a professional like a CPA to do taxes, then it's easier for them to reach out to the CPA. CPA typically knows where the assets are for the attorney, if they had an attorney.
Great. Somebody just asked about a planning packet and that there are some planning forms available. So yes, can you maybe just share that once again about the planning packets? And I know here we have a new one that we've also started to use called Prepare for Your Care. Is another form that we're happy to email over that might be helpful.
Yeah, and on the presentation, let me find the website, but the Arizona Attorney General's office has free forms. I don't know if I'm able to go back on this.
Yeah, you should be able to go back. And I was going to say, we do have those forms here. So if anybody needs them, they can certainly give us a call in the office, and we can mail them. We can mail a form to them as well.
Oh, nice. So, and then the website is listed there. The Arizona Attorney General's has the free state forms that Maya was mentioning. She can also mail those out to you as well. And they also provide assistance here to help fill those out. So if you need a witness or that's very useful. I would recommend that.
Yes, thank you. Well, I want to thank you so much for being here, Shanelle. I'm going to turn it over to our in-person audience and wrap up with online. But I want to thank you again for being here. We really appreciate it. Thanks again for being here. We look forward to seeing you next week. We have a few classes that are coming up. The Inside Story is Wednesday, May 22nd at 10 a.m. We will be featuring local centenarians. That is an in-person class only. If you are interested in attending, please give us a call at 520-324-1960. And then on Thursday, May 23rd, Moving Forward, Exercise for Breast Cancer Survivors and Thrivers. This will be with our TMC Adult Therapies, Maria Zaruba. She does specialize in lymphedema. And the class, it will be at 3 p.m., and that was Thursday, May 23rd. Again, the phone number is 520-324-1960. Have a great day.